Yes! Hello, my beautiful friends. What an amazing day it is. And welcome back. I hope that your holiday celebration, your Memorial Day was amazing. And you are rejuvenated, returned, and ready to go. And happy Tuesday, Taco Tuesday, Pupusa Tuesday, whatever you're into out there. Hopefully you're enjoying it. We got business to attend to today. 3 good segments queued up. We're going back down memory lane a little bit. Remember when they convicted President Trump of 34 counts of garbage? Well, we're going back into that one because we got the Second Circuit that is looking into this case, and we got some additional filings from Team Trump. We got this supplemental brief here filed by President Trump himself. Boom, because of course he was prosecuted individually as a private citizen. And we'll go through that, but also, since he's the president now, we got the Department of Justice who's also weighing in on this. We've got an amicus brief here. Obviously, this is the Alvin Bragg case, the falsified business records saying that he signed the checks illegally. Remember that whole document fraud case? Well, Trump is not going to just take this one lying down. We're going to see if we can get the case removed up into federal court. It was denied originally, but they're now trying to take it back up again and get rid of this conviction once and for all. So we'll go through that. We got a couple good filings here queued up. You can see we're in the Second Circuit Court of Appeals on both of these filings, one from the DOJ, one from President Trump himself. So we'll get into it today. Then we're going to go down to Florida. Remember that assassin, alleged assassin, the guy who tried to take out Trump, called Ryan Routh? Well, he has submitted several different motions here. Last week, we went through the order from Judge Cannon. Remember Judge Eileen Cannon? She's the judge who handled the Jack Smith prosecution. And she came out with another new order today. And guess what? Ryan Routh's attempt to suppress basically his identity. Ryan Routh said that he was a mistaken identity. They got the wrong dude. He fled the scene. They tracked him down. He says, you can't, the ID that when they looked at the photo lineup and matched this dude, they said that was under duress. It was improper. And Judge Cannon just issued a ruling on that today. So we'll read through it out of Florida. We remember spending a lot of time back down there before the election with Jack Smith, who's not even a real boy. And he's long gone. So we're back in Cannon's courtroom. Then we'll take a look at what's happening with the Secret Service, because apparently a couple of ladies over there were beating the hell out of each other. You see them right there. Secret Service agents talking all sorts of garbage. Someone saying, I'm a whoop this girl's booty. And looks like they're about to get into it. So we'll read through that. We also got some more reporting here from Real Clear Politics saying Secret Service got some work to do over there. And we also saw this from Joni Ernst, which is an interesting filing. Apparently, Secret Service is not alone. Remember when they were, I think it was like under Obama, when they were using those Colombian hookers down there in Colombia? Well, a lot of the DOD people are also using government credit cards for clubs, casinos, and adult entertainment. You know, a little tishy action going on at the DOD. And so this senator called Joni Ernst was sending a letter demanding some answers on this thing. And we'll see what these government civil servants were getting into at the strip club. So, bunch of great stuff to get to today, my friends. Really glad that you're here with us. Thanks for joining us. Thanks for subscribing. Thanks for liking this video. If your thumbs work, if your thumbs don't work, try to hit the like button with your forehead. That also will work sometimes. We have this weekend, your boy is going to be hosting a virtual tour at Eric's house, and we'd love it if you came and joined us. It's going to be Saturday, 11 a.m. Arizona, 2 p.m. Eastern time. It's going to be online digital tour of Eric's house. And Eric's house is a nonprofit organization that my mama created. My beautiful mama, seen right there. That's my beautiful mama. That's me. That's her son, Rob. That's Eric. Eric passed away due to suicide after a long bout with heroin and multiple surgeries. Oxycontin led to the heroin, and then he ultimately ended his life. And so Eric's House is an organization dedicated to people who've lost a loved one due to suicide, overdose, or tragic death. And so it's an awesome organization. There's support groups, men's groups, women's groups, all sorts of services. My mama created this group, founded it. It is a nonprofit 501c3, and your boy is hosting a tour. We'd love it if you came and joined us. You can click the link in the description below. Eric's House Virtual Tour with Rob this Saturday. Thank you for joining us. Thanks for supporting the work there. Lots of healing, lots of amazing people. And your boy will share some of the story, some of, my story, and should be exhilarating. So come check it out, ericshouse.org. Thanks for supporting the work over there. All right, so my friends, let's get into business on the day, because we are in the Second Circuit and we're excited about this. The Trump conviction case is not over. We're still taking this puppy up to the Second Circuit Court of Appeals. And today we've got two filings that are going to be trying to undo what Alvin Bragg and Judge Juan the Con Mercan did to President Trump when they convicted him, so-called, of 34 counts of business fraud. And then they said, well, we can only sentence you with basically nothing and just kind of close the case and wrap it up. But we're not done yet. Remember, they all said he's sentenced, it's closed, he's the president now, so forget about all that. Not so fast. Remember, when this case was first getting underway, Trump was being prosecuted. He said, this is ridiculous. I can't be prosecuted by Alvin Bragg and Judge Mercan in this corrupt state of New York. This is ridiculous. And he tried to remove this case up to federal court because, remember, they were concocting the statutes to create criminal charges against him. He was paying his lawyer in the form of checks for legal expenses. And they said it was a violation of FEC. They said it was a violation of tax code and all these things that were federal crimes, but he wasn't charged federally. Weird. How did that happen? So they used New York law to try to create a federal crime and turn it into a state crime, and they prosecuted him accordingly. Trump said, if it's a federal crime, you got to take me upstairs to the federal court. And so a long time ago, we rewind the clock all the way back, and you'll see that before the election, as Trump was being prosecuted, we got a notice of appearance. This is back September 4th, 2024, when Trump was being prosecuted. And he appealed this case. Remember, he filed a request to remove this in the lower level district court. The lower level district court here said, nope, you can't remove this case and take this up to federal court. So the case was prosecuted down with Alvin Bragg, with Judge Mercan, total scam. And Trump, this entire time, was filing to get this out of the state courts, right? We have two different parallel systems, the state and the federal court. And this whole time, this has been percolating. And now we've got some new filings. Look at all this stuff that has come in. But now, here is what we have. Trump has been granted permission to file supplemental materials, right? He's the president now, and there's a lot more to get into. And so we've got two filings that Trump has submitted. One, Trump filed it himself. Okay, so remember, he was prosecuted individually as a private citizen. And then we also now have the DOJ. Okay, so the United States government is coming in as an amicus, as a friend of the court, and supporting the idea that this case should have been removed. It should have never been in Judge the Con Mercan's courtroom. It should have been taken up here because it was a federal case. So we got two items that have now come in. This one is from President Trump for the defendant. And this is on appeal from the Southern District of New York. Remember, the lower level judge was not Judge Mercan. This is the federal judge who said, we're not going to allow you to remove this case, to take it up. And so Trump is appealing this to the Second Circuit Court of Appeals. He writes the following. All right, Court of Appeals. We got two things that are happening now. First of all, the United States, so it's basically two separate entities. Trump is a private person and the U.S., but they're in cahoots, okay? They're coordinating on this. So they're saying, oh, look, Trump says, hey, the United States DOJ that Trump runs now confirms that the federal officer removal statute permits post-judgment removal. So Trump is now not fighting the Biden DOJ to try to get this removed. That was Merrick Garland and those goons and Lisa Monaco who sent all their goons to say, oh no, Trump can't remove this, and the federal court bought it. But they lost. And now the DOJ is coming out and saying, hey, actually, this is how it really works. The United States brief also underscores permitting the removal of Alvin Bragg's criminal prosecution of Trump to federal court. They actually say it's essential. You need to do this. It's essential to protecting the autonomy and the independence of the federal government against state interference and loser hacks like Merchan and Bragg and Tish and Fannie and Jenna Griswold and the rest of them. Alvin Bragg's 15-page response doesn't undermine anything that we're doing here, Second Circuit, and so pay close attention. They say, as President Trump explained before, this appeal is still live. The case is not closed. Trump may have been sentenced and convicted, so-called, but the federal officer removal statute, Trump was being prosecuted for his conduct as the president at the time. He was in the office as he was signing those checks to Michael Cohen. It authorizes removal after the state court enters judgment in a criminal case. So just because Merchan convicted him doesn't mean it's over. The United States agrees with President Trump. Now, the United States correctly tells us the law is very clear. The law says, the plain language gives us this capability that federal officers may remove a state level prosecution at a later time for good cause shown. It's in the statute. We've got very good cause here. Now, in response, Alvin Bragg said to us that this language is silent on whether a case can be removed post-judgment, right? The case is over, Alvin Bragg says. You've already been convicted. Trump got no sentence at all because that would have been illegal. But they say that's wrong. We can remove it. The statute actually expressly authorizes Trump to remove any pending prosecution at a later time than before trial. At a later time than before trial, right? So it's not, you have to do it before, it can come after. A case is still pending after sentencing while it's on appeal. Happens all the time. People get sentenced, they go to prison, they appeal their case, takes years. And a removal in such a case is at a later time than before a trial. Now, the statutory text, because an appeal might send it back down for a new trial. Now, the statutory text thus plainly permits a post-judgment removal after the case has been tried for good cause. Now, even if the statute were silent about this removal, that silence would speak volumes. Trump says Congress knows how to require removal before a particular deadline. If they said that you couldn't remove this after a sentencing, they could have wrote it in there. The Federal Reserve statute, removal statute, for example, limits removal to literally before the trial, but the other statutes don't. The federal officer removal statute says it is literally at a later time than before the trial. So it can go way beyond before the trial limitation. Ignoring the law, Alvin Bragg, typical, would ignore the law. He says that there are other indicia that Congress only intended removal to happen before the sentencing occurs, right? Alvin Bragg doesn't want this to leave the court of Judge Corrupt Merchan, because if that happens, then he'll be in front of a real judge and not a biased partisan hack. But Alvin Bragg's mishmash of weak structural inferences cannot overcome the law. Saying President Trump has already made clear that Alvin Bragg's position doesn't actually follow the law. He's citing a bunch of statutes and cases, but it's not what he says they say is not what they say at all. Saying the United States also rightly points out that decisions from other circuits unanimously support the availability of Trump removing this. Bragg says, well, none of those cases are controlling. He says, well, those are all civil cases. And so they removed them for civil cases. And those were in criminal cases. And we're prosecuting Trump for business fraud. But that distinction makes no difference. Removability is removability because the statute says civil or criminal. It applies to both, Alvin. So Bragg then turns around and he says, well, you know, civil litigation is unique. And so civil might justify removal, but this is criminal. Now, for starters, that's not what Congress wrote. So that might be Alvin Bragg's interpretation of it, but just read the law. And no courts have relied on that distinction at all. Indeed, if there even were a distinction, which there isn't, it would run the other way. Okay, Congress would be most concerned about criminal prosecution of federal officers. Like if they're going to allow you to remove because you're being sued civilly, they're obviously going to have, and the power, the ability to remove has been granted by Congress to protect you against state prosecutions. So if it's a state suing a civil officer and they'll allow you to remove it, if it's a state prosecuting a civil officer, they'll clearly allow you to do that too, because that's an even bigger infringement on that executive official. Now, as the United States explains, right, so this is Trump as private Trump saying that the DOJ is also supporting us. Congress might have had many scenarios in mind when authorizing post-judgment removal after the criminal case. For example, after judgment, Congress might even enact a new statute. The U.S. Supreme Court could issue a landmark decision, as happened here, remember? Or prosecutors could introduce evidence that implicates an evidentiary immunity, as they did here. Now, the very point of the statutory good cause standard is to provide a safety valve and, good cause should they arrive. The United States, Trump DOJ, also explains why this safety valve is critical to avoid gamesmanship by state and local prosecutors like Fannie, Bragg, and Tisch, who may at times be hostile to federal policies and federal officers. Chris Mays, Dana Nessel, Jenna Griswold, the rest of them. Particularly during periods of national stress when they're all going to lose an election. And so they have to do anything they can to stop the dictator Trump. Now, Alvin Bragg responds. He says, well, New York has criminal procedures and we follow our criminal procedures here in the state. But Trump says that's a non sequitur. Who cares what that says? The issue is not about what the state and you guys do there. The issue is what Congress wrote in the statute. That applies to all 50 states, including yours, Alvin, and to a host of local prosecutors with varying incentives and audiences. Now, at any rate, Alvin Bragg, the New York prosecutors, self-serving praise of New York courts. He's like, we did such a good job. We handle things so appropriately. We're definitely not partisan hacks too. And I'm skinny. And that the trial court abused its discretion in failing to recuse. Mercan's daughter, remember, is doing advertising to oppose Republican opponents, in particular Trump, and was working for Adam Pencilneck Schiff and was running advertisements for him where they were supporting the idea that Trump had just been indicted. Pencilneck Schiff on Facebook posting things, Trump just got arraigned in New York. Finally, justice coming to America and all that crap. The judge's daughter was getting paid for that. Daddy was prosecuting Trump. Daughter was making social media posts about it and selling it to Democrats. So they didn't recuse, and Alvin and the rest of them are just patting themselves on the back like we did such a good job. We're such amazing people. We're prosecutors, and a lot of them think this way. It's pretty wild. In fact, they say this is the whole problem. This exemplifies the concerns of the government about the possibility of hostile treatment by state and local prosecutors if post-judgment removal is unavailable, right? If the states can attack federal officials, that's the problem. That's why Congress was acting in the first place. That's why they did this. That's why they passed this law. Now, as President Trump will show on his direct appeal, Alvin Bragg was dead wrong. The Federal Election Campaign Act preempts the state election law that Alvin Bragg was using to prosecute Trump. And it required the removal of this, right? It's a state level prosecution. They can't prosecute federal crimes. And they were saying that they could basically tuck in that federal crime into another sub-statute in New York law that said that any other, kind of a catch-all provision, they said, well, that counts, even though the feds didn't prosecute Trump for that. So they just gobbled up that claim and tucked it into New York law. They can't do that. When Trump first removed this case before the trial started, Alvin Bragg and Mercan, they persuaded the lower level district court that there was no federal preemption defense. They said, well, the mere possibility that they could convict Trump, the way that they wrote this, remember there was that subsection and they said, well, it could be a violation of tax law, it could be a violation of New York election law, could be a violation of federal law. Like they gave a bunch of possibilities and the jurors could just pick a card, any card, whatever they wanted to do. Oh, that's a conviction for Trump. Sure, I'll take another one. Yeah, draw two, draw another one. Sure, no problem, until they get him. And that means it's not unanimous because different jurors can pick different things. Somebody can say New York state law. Somebody can say federal election law. Someone can say New York tax law, not election law, whatever they wanted. But the lower level court said, well, we don't know what they're going to present in the trial. And so if you're making the claim that they're going to prosecute you based on state law, that hasn't happened yet. And so we can't give you relief yet. They said it was too speculative because Alvin said he was going to introduce other first layer predicate offenses, which would be tax violations or other falsification of business records that weren't relying on federal laws. But at the very end of the trial, that prosecutor called Alvin, who didn't even do most of the case, he just kind of sat there like Tisch did, abandoned all of the other predicates, forgot all about those state laws that it cited to to avoid the pretrial removal to federal court, and they put to the jury only the New York election law predicate. He violated New York election law. Oh, well, you can't charge that, Alvin. Bragg, though, still has nothing to say in defense of its obvious and highly prejudicial bait and switch, telling the judge, oh, no, we're not going to use that. We're going to charge him under other things. And at the last minute, knowing that there was no other violation of other laws, they just shoved that one in there. I'm going to make that work. This court should not permit Alvin Bragg to avoid removal now. He misled the lower level district court, and he tried to avoid removal pretrial. And by the way, the judge has granted, the permission to file this in the first place, hinting that the judge is kind of noticing that, saying, oh yeah, Alvin, you came in here and you told me one thing, but then you lied to me. And then you presented an entirely different theory of your case to the jury. So how about, yes, we do grant Trump the ability to file a supplemental brief. That's what he's doing now. Alvin's not in a good position here. Finally, Trump writes, as a private citizen being prosecuted, he says the United States also explains that because, and by the way, the old United States was Merrick Garland and Alvin Bragg's liaison, which was Matthew Colangelo, who was Biden's number 3 at the DOJ before he left to go start a franchise prosecuting Trump in New York. Finally, but that was all, rigged. This is how it actually works, right? You don't prosecute federal officials from the state level. That because post-judgment removal is available, this case is not moot. In fact, the district court, we're in the Second Circuit now, but the lower level judge can grant leave to file a second removal notice, adopt the judgment of the state trial court as its own, and transfer this case to the court for appellate proceedings. And this court should direct that this procedure be followed here. After reversal of the district court's order denying Trump leave to be here, right? Now, in protesting, saying this case, Alvin Bragg says, no way, this is going to be novel. Alvin Bragg, though, is ignoring many other cases that have already done this exact same thing. Harris, cited here, federal practice civil procedure, and they're also getting more cases. They're like, Supreme Court will supplement this. This happens a lot. Trump also says, hey, the DOJ is also saying there's good cause right now for this removal proceeding. So you got to reverse that district court judge. The United States DOJ is also correct that President Trump here has at least 2 federal arguments that are going to win. First, presidential immunity and federal election law preemption. These easily exceed the appropriate low bar of a colorable defense and allow him to take this to federal court. He meets the threshold based on these 2 issues. Now, Alvin Bragg ignores that standard of review. Instead, he wants to go rehash old arguments that aren't relevant, but his arguments are terrible. First, Alvin contends, he says that, well, there is no case, Alvin says. No case. Come on, no case, Alvin? Come on. Stands for the proposition that the mere introduction of evidence concerning official acts is enough to make a criminal prosecution immune under the act. Now, that proves nothing because no case says the opposite either. This is the case of first impression. Never before has a psycho prosecutor and a lunatic judge done something like this. That's why it's brand new. Now, not surprisingly, no court has had to examine how the federal officer statute applies to evidentiary immunity. So in other words, they were introducing evidence against Trump that was protected by the Supreme Court's decision on presidential immunity. The president is allowed to do certain things by the power of the presidency. And if you're going to prosecute him for doing those things, you're prosecuting the president for following the Constitution, which means your order is unlawful. Or your evidence cannot be used against him because he's got the power to do the thing. And they did that. They introduced a bunch of that evidence, invoking peculiar constitutional concerns, which comes from prosecuting a former president for his official acts. Because remember, Trump wrote the checks in 2017 when he was in the White House. Now, as both Trump and the United States have explained, the statutory text confirms that Congress approved removal in this exact sort of circumstance. But Alvin Bragg doesn't even try to address these arguments because he's terrible. He knows he's going to lose. Now, second, Alvin Bragg also says that federal officer removal is available only to current and not former officers, saying, well, President Trump was a former federal officer when he tried to remove this. But Bragg has forfeited that argument. It didn't even raise that argument and didn't even make those merits before the court. So he's now trying to shoehorn a new argument into the Court of Appeals, but that was never argued at the lower level. But even if you want to think about that, Court of Appeals, he's also wrong. States cannot escape federal officer removal by just waiting until they're out of office and then charge them for stuff that they did while they were in office. As the district court explained, the very purpose of the removal statute is to allow federal courts to adjudicate challenges that are done under the color of federal authority. Now, at a minimum, federal officer removal must be available to President Trump, and it should have been, especially in light of the Supreme Court's holding that the nature of presidential power also requires that a former president be immune from criminal prosecution for acts during his time in office. If you're going to charge him for activities and conduct during his time in office, that conduct enjoys the powers and the protections of the presidency, obviously. Finally, even if removal were available to only current federal officers, guess what? Trump is a federal officer again. Eat it. And so he's going to remove it. Now, the submissions from the United States and Alvin Bragg also confirm that Trump had the necessary good cause to file this removal because he had no opportunity to raise this immunity defense or any other preemption defense at any time. And remember, in the other prosecutions, Judge Chutkan kind of paused everything as soon as Trump started invoking immunity. And as terrible as she is, that was the right thing to do. Supreme Court allowed this to go up. They ruled on it. She came back down and dismissed the case. Merchan didn't do that because they're at the state level and they were a team on a mission, which was to convict Trump before the election. It's the only opportunity they had to win because they were running an invalid and then Kamala. But I repeat myself. The United States focuses on presidential immunity, says Trump. And we correctly maintain that good cause for removal after this sentence exists. Neither the existence of that evidentiary immunity were established before prosecutors introduced evidence here. Without citing any authority, Alvin Bragg, he disputes. He says, well, a late-breaking legal development, that's not good cause for removal. So what if the Supreme Court came out and said something like, we already got this thing done. And since we got it done, there's nothing you can do to undo it. But both analogous precedent and the law, says Trump, confirm that if grounds not existing at the time arrive later, that alone is good cause. Now, Alvin says there was no good cause here because Trump's immunity defense is intertwined with state law issues, and it's too complicated. Since we have some rights to handle this case, he can't remove it. Trump says no. That's incorrect too, Alvin. He points to its argument that any violation of evidentiary immunity was harmless. Okay, so Trump, well, we introduced some stuff that said Trump did this while he was the president, but it's not a big deal. That is a federal law question, though, not a state law case. Alvin Bragg's harmless argument is also meritless. Now, he separately says that Trump failed to preserve his immunity argument, but he did. In fact, the state trial court, Merchan, actually found that Trump properly objected to much of the evidence at issue, including testimony. Remember they brought in Hope Hicks? She was the White House comms director. They brought her in, said, tell me about everything you did in your office. Violating executive privilege, violating Trump's immunity to actually do those things, all introduced. They also introduced his official statements on X. Now, regardless of Judge Merchan's ruling, him saying that other objections were not preserved is wrong, right? And remember in the trial, the judge is like, will you stop objecting, please? Just quit it. Sit down and close your mouth. And then Trump said in the aftermath, well, you didn't even let us object. He says, well, you didn't object. He said, well, you didn't let us object. He said, well, you should have objected more forcefully. He said, you told us to sit down and shut up, but you shouldn't have shut up. You should have objected to preserve the record. And since you didn't do that, now you lose that opportunity. That's how biased this judge is because of his partisan hackery and family. Now that ruling, like any other ruling of the trial court, should be reversed. Obviously, that's wrong. On Trump's preemption defense under the federal election law as well, Alvin has nothing to say in defense of what he did. He tried to hide the ball at the first level. Instead, he says that Trump lacked a good cause to remove this because of other state law issues. But a federal court should not decline to exercise jurisdiction just because there is some state law in the case. That's common in removal cases. We always have to separate the two. Now, that Trump has other meritorious arguments, many of which are coming from the unprecedented, unlawful, and convoluted way that Alvin Bragg bent the law to fabricate a felony charge here, is not a strike against removal. If anything, the novelty of Alvin Bragg's theories confirm Bragg's hostility towards President Trump and thus support the removal. In any event, given the strength of Trump's immunity and his defenses, there may actually be no need for this court to consider state law issues at all. It's so cut and dry, you should just take it, remove it. Now, finally, Alvin Bragg says that permitting Trump here to remove this case would trigger a whole slew of additional procedures. This is going to slow the case down. This is going to have to remand it back down to the district court. And then they're going to have to revisit all this. He says, no, that's not warranted here. The district court already denied Trump's attempt to remove this case. That was denied. Now we're appealing it. And we've extensively briefed this legal question. Questions are whether this case meets the bar for federal removal. It does. Should have been removed in the beginning. Is there good cause to remove this case after the trial? Yes. And this court should resolve those questions now. You, the Second Circuit, should determine once and for all that this unprecedented criminal prosecution of a current and former president of the United States belongs in federal court, not in the disgusting judges Mercan's gutter courtroom. The court can then move to direct appeal and review of that prosecution using the procedures that have already been outlined. And so, in conclusion, Trump's defense team, Robert J. Gouveia Jr., says the court should reverse the lower level judge's order, denying Trump the right to remove this case to federal court and allow this appeal to continue on in a very nice filing that is in this brief supported by the DOJ. Here is an amicus sent in on behalf of President Trump from the DOJ Civil Division supporting Trump's demand that the federal courts take this case away from Judge Mercan and Alvin Bragg. And they're going to give us a nice legal framework to support this. They say, all right, look, the DOJ represents all sorts of federal officers who are at risk under state law because they're doing their job. Section 1442 was the law protected to passed to protect these people, and we're going to invoke it now. The United States has a strong interest in this, and so we're filing as you see. Now, a lot of this is giving us some detail, right? This is the DOJ. This is how it works. These different sections allow you to file accordingly. Now, the background here started in March 2023. You remember, Democrats absolutely losing their mind. Trump is looking like he's up in the polls. Joe Biden can't talk. Kamala Harris, one of the most incompetent people in the history of American government. So what do? They try to remove Trump from the ballots in multiple states, and then they indict him in multiple locations. 2 federal prosecutions and state prosecutions, one showing up March 2023. Alvin Bragg, Judge Mercan, and the New York grand jury returned an indictment, 34 counts. They said Trump had intent to defraud. His business records were bad. But then in May, Trump tried to remove this case. His notice was based on anticipated federal defenses, but that never happened. The district court sent the case back down to Mercan. It determined that the removal statute was improperly invoked. But the case proceeded to trial. Trump found guilty on all counts. But then on July 1st, after Trump's state criminal trial, after the trial was over, the Supreme Court came back down and said the president is entitled to absolute immunity from criminal prosecution when the president is acting under core constitutional powers. And gave us the 3 buckets. If it's core constitutional power, you get absolute protection. If it's within the outer perimeter of official responsibility, you get a presumption of immunity. And if it's outside You get no immunity if it's outside of your official acts. But they never even did that analysis in this case when Trump was prosecuted. After the Supreme Court's decision saying, oh yeah, we've got immunity, Trump filed a post-trial motion to dismiss the indictment and sought leave for removal. He said the state introduced improper evidence of official presidential acts. They brought in testimony of Hope Hicks, testimony of Madeleine Westerhouse, Michael Cohen, all people who literally worked for the administration at the time. Now, days later, the district court denied the motion, declined to permit the removal notice to even be filed. They said, well, you have to show good cause, and Trump hasn't done that here. But then another denial, and the court explained, well, they're private acts, and so the lower level court, the state trial court, this is Judge Mercan, said, no, you're not entitled to any immunity at all. And the trial court then sentenced Trump to an unconditional discharge, right? So his 34 counts, criminal convictions, 34 felonies, unconditional discharge of all penalties. Nothing could be done. Trump appealed it, and here we are. So you see, the rest of this has given us a lot of the same stuff that Trump said. Trump referenced a lot of this in his filing, but saying the plain language says we can remove this. Even the DC Circuit said we can remove this. This decision in Harris supports our claim as well. And the Court of Appeals in the DC Circuit supports our claim as well. And because all of this involved presidential claims, Trump has raised a colorable defense under the law and met the showing. He's identified certain categories of trial evidence. There was testimony about literally him being inside the Oval Office with the Attorney General. They brought in the White House comms director. In fact, even in the Supreme Court decision, they held that Trump's private conversations with his Attorney General were official acts. His conversations with his team can't be used against him. The notice of removal says that prosecutors introduced prohibited official acts evidence, and they tried to draw inferences from that. And because they did that unlawfully in violation of the Supreme Court rule, Trump has a claim. They say the state can argue all of their evidence at the higher court, but the higher court gives a federal forum for Trump to assert his defenses that Judge Juan the Con Mercan never allowed him to pursue. They say Trump's post-trial removal notice is timely. We filed it on time. There's good cause here. It was not until after the criminal trial occurred that the Supreme Court issued its decision. And that decision resolved for the first time in our nation's history that the president has constitutional immunity for criminal prosecution for presidential acts. Now, neither the existence or any other immunity support this conviction, and the refusal to find good cause here from the lower level judge is an abuse of discretion. Saying the Supreme Court, in sum, the unusual circumstance in which the federal official is tried here has been met. We've established good cause. And therefore, we ask that you reverse the lower level district court and allow Trump to remove this case up to the Second Circuit Court of Appeals and present his defenses and throw out these corrupt convictions from Alvin Bragg, Judge Juan the Con Mercan, and the convicted perjurer liar called Michael Cohen. Good filings there. We'll keep our eye on this one out of the Second Circuit. Thanks for subscribing and joining as we do. And hopefully the Second Circuit gives us a nice victory and says, yeah, this was a federal case and claim. The Supreme Court gave Trump proper immunity. Judge Mercan should have paused the case and allowed that issue to be fleshed out. He didn't. And so now convictions gone. All right, good updates there. Now let's turn our attention over to Florida, because this is the case of the Trump assassin. Ryan Routh, the attempted Trump assassin, now loses again. He's been fighting his case, multiple charges, including being a prohibited possessor, having weapons as a convicted felon. Those are kind of the minor charges, not to mention the attempted assassination of President Trump on the golf course. But this case is coming out of Judge Cannon's courtroom. You remember her from the classified documents case, and when we had Jack Smith bringing his fake crimes against President Trump in that district in West Palm Beach, Florida. But now we've got a bunch of activity here from Ryan Routh. He's gotten defense attorneys and filed a bunch of different motions here. He filed a motion to dismiss his case, which was denied by Judge Cannon, but he also filed a motion to suppress certain evidence from coming into trial. Now, the original motion to dismiss we read through here was about gun rights, essentially. He was charged with obliterating a serial number and being a prohibited possessor. Judge Cannon said, those charges are not going away. They're going to continue against you. So now he's turning to kind of the backup plan. All right, let's suppress some evidence here. And part of the evidence that he wants suppressed is his ID. Judge Cannon denied it, and here's what she wrote. She says, all right, listen, the case, of course, is the United States of America prosecuting the surviving Trump assassin whose body has not been burned within 10 days, Ryan Wesley Routh, charged in Florida. Judge Cannon writes the following, says, now this matter comes before the court based on Ryan Routh's motion to suppress bits of evidence. One is an out-of-court and in-court identification under the Due Process Clause of the Fifth Amendment, saying that the IDs of Ryan Routh, the assassin, were biased. There was duress. There was pressure. Cannon says, the court has reviewed the motion. The United States, their opposition, Ryan's reply, and more. The court also held a non-evidentiary motion to discuss this matter. And after everything, Cannon says, Ryan Routh's motion to suppress the ID is denied. Because the show-up identification procedure was not unduly suggestive. Nobody was like saying, oh, that's him, it's Ryan. And in any event, the show-up ID was reliable under the circumstances. Now, the court exercises its discretion to resolve this motion without an evidentiary hearing because Routh has not raised any material disputes of fact. And the facts alleged here don't warrant a grant of relief. All right, so let's see what the argument was that Cannon will deal with. She tells us, Ryan Routh, the alleged Trump assassin on the golf course down in Florida, seeks to suppress a show-up identification and a subsequent photo presentation made by civilian witnesses. So some guy comes in, TCM, and says, yep, that's the photo, and then points him out in person. Routh also seeks to preclude this witness from testifying in court to say, yes, I saw him flee and I identified him. Now, the factual background contained in the motion in opposition, along with the accompanying transcripts of the show-up and the pre-show-up sworn statement, present the following facts, and nobody is really disputing these. Okay, so how was this ID made? Cannon reiterates. She tells us, at approximately 1:30 p.m., September 15, 2024, this witness called TCM was driving near the Trump International Golf Club in West Palm Beach, Florida. His car windows were up. He heard what he thought were 3 gunshots. He saw a pretty unkempt white man running from the bushes, lining the exterior of the golf course. What the heck? He looks over. Pop, pop, pop. Dude's running. He then witnessed the man cross the street towards a parking lot, drop a black object through what he described as the sunroof of a parked black Nissan Xterra, got into the car. Based on the man's body language and how he was running, TCM, the witness, felt the man had done something that he did not have any business doing. That dude's hightailing it. Decided to follow the vehicle for a few blocks so TCM could provide some info about the shooting. In the course of doing so, TCM used his phone to take 3 pictures of the vehicle, and he recorded a short video. He also wrote down the license plate number, which was 97EEED. Wrote down the make, model, and color on a piece of paper. He also wrote down on the same sheet, blonde, white, male. After following the vehicle for a brief period, the witness decided to return to the location of the shots fired. When he got back to the scene, he saw the Secret Service presence there, several police cars. He then verbally relayed the information he gathered to law enforcement on the scene. Says, hey guys, I just saw this dude running from here. I wrote all this down. Shortly thereafter, also at the scene, a detective came. Says, what'd you see? As taken from the transcript of the sworn interview, attached to the United States opposition, TCM described the events above, noting that when he took the pictures, it looked as if the individual looked right at me. Made eye contact. TCM also identified that the fleeing individual wore a light-colored shirt, was in his early to mid-20s, was a white male with blonde, unkempt hair. He tells us, at 2:09 p.m., before the start of his sworn statement, Martin County Deputy Sheriff stopped the black Nissan Xterra with the same license plate on I-95, 40 miles north of the golf course. Police arrested Routh, who was driving the car, surrounded the vehicle with numerous officers, shut down the interstate northbound. Police then promptly arranged to conduct a show-up with the witness called TCM. Now, to do so without delay, they escorted TCM to the police aviation unit. They put this dude on a helicopter, flew him to the location of the traffic stop on the I-95, then drove him to the police station where he was being housed, Ryan Routh. Now, at 3:35, before conducting the show-up, police gave a series of instructions to the witness. Now, it's all memorialized. There's a written transcript of the body cam footage. Cops are talking to him on camera. Police cautioned him that the person that he would be shown may or may not be the perpetrator. Hey, we're going to show you a bunch of people. He may not be in here, okay? Just so you know. And you don't need to be compelled to make a positive ID. We're going to show you pictures, but if you don't see him, don't say it. Don't say it. The investigation would continue whether or not you ID this guy, all right? So like if you can help, great. If he's not in here, don't force it. TCM said, do you understand? Yes, I do. No problem. So then at 3:41, with Routh standing outside of a police vehicle next to a deputy, police asked TCM the following question. Does that appear to be the individual that you saw running from the south side of the golf course across the street to the black Nissan? Ryan Routh standing there. TCM says, well, it does look like him, noting same hair, same build, same facial features. Now, footnote 2 tells us, the witness did not take a photograph of the individual himself, and he could not identify the specific light color of the man's shirt. So police then started to put out the defendant into the back of the car, Routh. At which point, TCM said, hey, could I see his side too? I just want to be sure. Defendant turned to the side, following which TCM said, yes, sir. Yes, sir. Police said, all right, hey, TCM, take all the time you need. Is that him? There's no rush here. When asked how confident TCM was that Ryan Routh was the person he saw, he said 99.9. All right. 99.9. This show-up was completed about 2 hours after TCM spotted the defendant running away from the golf course, so it's very recent. Now, after the show-up, police transported the defendant to the police station. They photographed him about 6 hours later. FBI also came and interviewed TCM. They showed him a single photograph of Routh. Hey, is this man the guy you saw fleeing? Now, that's a single photograph, right? It's not a lineup. TCM says, yep. The U.S. does not seek to introduce evidence of the photo at trial, right? So they're not going to introduce that photo. And the order accepts that representation. So the judge will say, well, was that lawful? Was that too biased or what? Says, here's how the rules work. An identification procedure is unconstitutional. It violates the due process clause of the Fifth Amendment if it's impermissibly suggestive and it creates a possibility or a likelihood of misidentification. Trial courts conduct a test. They ask this question: was the original ID procedure unduly suggestive? They say show-ups are not unnecessarily suggestive unless the police are aggravating the situation. Only if the court concludes that the ID was unduly suggestive would they need to consider the totality of the circumstances. And let's do that now. She says, This court has the discretion to decide whether to conduct an evidentiary hearing to dig into this if needed, but we don't. And we can cross-examine these things if necessary as well. But we've decided that, she says, a hearing was enough and we conducted the hearing. Now into the ID. She says courts have found that show-ups that are held at or near crime scenes without aggravating police conduct, like if they grab the guy, is this the guy? Those are not unnecessarily suggestive. This is because the immediate confrontations allow the ID before the suspect has altered his appearance while the witness's memory is still fresh. And it permits the quick release of innocent persons if it's not the dude. But Routh nonetheless argues that police did create a highly suggestive environment. They actually transported this dude on a helicopter and then by a car to the location. They said they had the dude, a single individual, surrounded by law enforcement in handcuffs. The entire interstate was blocked off. Like, this guy has to flag this guy or else who do they have? The United States responds that various courts have permitted this. You can have people in handcuffs. Police can caution the witness, but none of that is actually aggravating. The court agrees. They said, yeah. Judge Cannon says it was not unduly suggestive. She says, first, the fact that Routh was in police custody and handcuffed does not necessarily make it suggestive. In other cases, other people were standing around, other cops standing around in this case, and in this case, and in this case, and all of those were fine. And second, Ryan Routh's defense does not provide any facts showing that the police aggravated the show-up. In 2 hours, they acted promptly to bring the witness back to the scene where he was recently stopped. When they got there, they gave the witness careful warnings. Don't feel any pressure. You may or may not have seen this dude. And so all of that did not unconstitutionally enhance the suggestiveness. Now, while Ryan Routh cites that these particular circumstances can aggravate the scene, like there was a lot of cops there, the highway was blocked off, he was in handcuffs, a helicopter transported him. None of that shows that that would have been sufficient to suppress the ID. And in fact, the 11th Circuit has already stated, saying immediate show-ups are allowed when the memory is fresh. And he doesn't provide any basis to show that the police exacerbated any of the actual suggestiveness here. So based on that, the court doesn't need to go into further analysis, but we will. Even if the defendant had shown that it was suggestive, unduly suggestive, the totality of the circumstances say it was reliable. And reliability is actually more important than unduly suggestive. Here are some factors. Was there an opportunity of the witness to view the criminal at the time of the crime? Like, did this guy say, I got a good look at him? He did. How much of a look? What was the degree of the attention? What was the accuracy of the description? What was the level of certainty that he demonstrated? 99.9 is what he said. What was the length of time? Just a couple of hours. So given all of those totalities, Judge Cannon says his ID was reliable. In fact, this witness had sufficient opportunity to view him, got contemporaneous documentation of his vehicle, took photos and video of the male's vehicle, wrote down the description of the vehicle, lots of detail. He was attentive and saw a lot. There are also accurate and inaccurate portions of the description. Some of it was not accurate, like he's not in his 20s. But in the totality, the judge says it does seem significantly accurate. The description was accurate because he described him as a white male, blonde, unkempt hair, looked right at him, said 99.9% on a scale of 100. In addition, he also accurately identified the make, model, and the color of the vehicle, all concrete details that he memorialized almost immediately. And as to his mistaken ID of his age, he said early to mid-20s. The dude is 58, though. That alone does not make it unreliable. And the vehicle doesn't actually have a sunroof, but that's kind of a minor discrepancy. because he conveyed everything else with 100% confidence. And also, there was only 2 hours as well between the show up and that time period has been upheld previously. And so, Judge Cannon out of Florida writes, suppression is not warranted here, saying Ryan Routh can cross-examine this witness. When this witness comes in and points him out in court, you can cross-examine him. You can say, well, there was a sunroof and you got the age wrong and all those things. But the jury can listen to the testimony and make their own conclusion. And so cross-examination is the right remedy if they don't like this testimony. Otherwise, the motion to suppress Ryan Routh's ID, according to Judge Eileen Cannon in Florida, is hereby denied. Ryan Routh loses that one as well. So many attempts to get this case dismissed and deviated from conviction, but so far Judge Cannon denying his major motions, and what we'll see is this case continue to progress towards trial, and we'll keep our eye on this one. So Ryan Routh loses another one. Judge Cannon will hold the case. We'll see if trial gets scheduled and cover it accordingly. Thank you for subscribing and joining as we do. All right, and so some good updates there, my friends. Now, let's talk about the Supreme Court, because we got some drama going on over here. I'm sorry, from the Secret Service. A Secret Service scuffle underway, and now we've got videos of two apparent Secret Service agents trying to beat the heck out of each other. This video came over from Susan Crabtree telling us that RC Politics, Real Clear Politics, has now obtained video footage of a fight between two Secret Service women in the uniform division when they were beating each other outside Obama's residence last week. One of them called their supervisor and said, "You better get over here before I whoop this girl's A." The skirmish raises new questions about whether DEI is still plaguing the Secret Service, even though Trump said get rid of it. Secret Service not responding to any inquiries. The video's coming up, but here is what Susan Crabtree reported previously. It says two female Secret Service division officers in uniform got into a physical fight outside Obama's D.C. residence while they were guarding it. The fracas occurred at 2:30 in the morning last week, early on Wednesday, according to two sources in the Secret Service community themselves. The lack of professionalism was on display during the fight, and in a call, one of the women made a recorded Secret Service line she called and requested a supervisor come to the scene immediately before I whoop this girl's A. The woman officer who made the call was upset that her shift replacement was late and assailed her verbally and physically when she finally did arrive to relieve her. Audio of the call is now circulating among agents, and we'll listen to it in a minute. It's unclear whether either woman was injured or whether they will be disciplined over this. The fight did not wake anyone in the Obama residence or the surrounding neighborhood. The incident is raising concerns about the lowering of hiring standards and saying, well, maybe there's a DEI push to add more minorities and women to the ranks under Kimberly Cheadle, who was one of the worst Secret Service directors in American history, who got Trump shot in the head. Cheadle says she resigned under a cloud of the Butler attack, and the Secret Service has experienced low morale and a severe manpower shortage, which is now contributing to this. And here is what the call sounded like. Secret Service agents beating each other's A's.
Immediately before I whooped the girl's ass.
Oh! One more time.
Immediately before I whooped the girl's ass.
Oh, wow. Okay, so Secret Service agents beating each other, apparently. Here's what the video looked like of these two going at it outside Obama's residence. What's going on over there? Wow! Secret Service. Man, she shoved her out of the way. Get off my shift. This is my shift. You're supposed to be here earlier. Get the heck out of here. 2 Secret Service agents outside protecting the Obama residence. So not looking good. An incident that involved a physical attack. This was another article from Susan Crabtree, and this one I think was a while ago. A Kamala attack, which occurred April 25th. That's right. Remember that one? Another Secret Service agent was removed after physically attacking the commanding agent in charge when they were protecting Kamala. So it's just a disaster over there, but at least they're not protecting Trump. You know what I'm saying? So if they want to beat each other outside Obama's residence, that's fine. Now, Joni Ernst is wondering where a lot of this corruption is going and sent a letter over to the Inspector General, the Comptroller General. Senator Joni Ernst says, DOD bureaucrats have made 11,000 transactions with credit cards that are known to be high-risk merchants. Clubs, casinos, and adult entertainment. Maybe some Grey Goose for Fanny. Who knows? James Comer and I are calling for a complete review of all federal credit cards and their use to stop this abuse. Here's the letter. All right. Dear Comptroller, for decades, the GAO, Government Accountability Office, has uncovered persistent waste, fraud, and abuse in federal charge card programs. And a recent audit revealed that we have about 4.6 million active charge cards and accounts. 4.6 million. Credit cards from bureaucrats. That's part of the problem. They spent $40 billion in the last fiscal year alone. Now, recent reports have found that agencies consistently fail to use modern tools to identify waste and fraud. In fact, in a recent review, the GAO found that none of the programs could provide examples of even looking at card spending patterns. No one even checks. This lack of oversight is further underscored by another report. The DOD Office of Inspector General found 7,800 transactions at known high-risk merchants, including casino ATMs, mobile application stores to buy all their Candy Crush points. The report also found 3,246 purchases made at bar lounges, discos, nightclubs, taverns, alcoholic drinking merchants, holidays, major sporting events, and more. Now, we're skeptical that any of these purchases were made in support of the DOD's mission. And this is not the first report the DOD has conducted in recent years. This is because the DOD has found that we haven't used any anti-fraud policies at all to identify fraud and waste and abuse. Tens of billions of dollars go out. And so we want to know how you're spending this money. Specifically, we want the following questions answered. What criteria do you use when you give employees credit cards? Do you monitor these at all? What is your training using Smart Pay? And how much money did you spend on all of these things? Wow. Dating, online dating for their swipe apps, matchmaking services, all their OnlyFans subscriptions, bail and bond payments for their crimes, gambling, put it all on black, state lottery, cannabis and marijuana, babysitting while they're out at the casino, childcare, jewelry, horoscopes, weight loss, that's one you might want to actually get behind. They actually used it for weight loss. Massage, cruise lines, telemarketing, boat dealers, boats, campers, fur shops, wig and toupee shops. Oh, it's amazing. Fanny's getting a weave, record shops, and more. All right, so all of it continues going on. Timeshares, massage parlors, casinos, horse racing, gambling, state lotteries, and more. Just amazing. So how much of this was spent on each of those things? How many agencies spend on charge cards and late fees? How many inactive cards do you have? Please ID all of your management programs, what qualifies as a split purchase, and more. Give us this information and give it to us now. Signed, sincerely, your friends, Joni Ernst and James Comer. I can't wait to see those numbers, man. So Hopefully we know how many wigs and weaves the Biden officials got for their staff, and they get to the bottom of it. So Secret Service in disarray, DOD spending money like lunatics. We'll keep our eye on this. Hopefully those credit cards get cut. All right. So my friends, what a beautiful day and a beautiful stream it has been. Thank you for joining us on this lovely Tuesday. SpaceX is launching. All right, let's check it out. SpaceX launching right now. 9th test flight. Oh!
For safety in advance and in an ongoing basis during our test campaigns to plan for as many possible outcomes.
All right, they got 24
minutes. I want to
minutes.
say thank you, though, to the people of the Bahamas, the government of the Bahamas, who worked with us so
Did it launch?
since Flight 8.
Or no?
We took full responsibility for the cleanup, and in doing so, we had people on the ground.
All right, hasn't launched yet.
In 12 hours to help with debris recovery.
24 minutes. So that's the countdown, right? All right, amazing. So we will keep our eye on that, my friends. Thank you for joining us. Glad we didn't miss that. Let's see who is here and joining us. Thank you for sending in these donos. Thank you for sending in your support of our show. Thanks for becoming amazing membos. New membos, we had a great members only stream this morning, so you can grab that one and say what's up from this morning. Hey, we got some donos here. Hey, what's going on? Thank you, Donut, for clipping for us on the day. We got Pooh Bear says, I'm getting ready for that taco because you know it's Taco Tuesday or Papusa Tuesday. The countdown clock is correct. Okay, amazing. Amazing. All right, so thank you, Donut. Mock Schnell is here. Thank you, Mock Schnell. Check this out. Bringing in 20 new Membo friends. We got Cat 4 Hair is here. Average Week. Jeremy Pattison, what's up? KM Angel 59. Professor B is here. Jonathan Venstra. We got Heath Wilson. Scar Scout. What's up, Noel West? Amy D, Johnny, and Lynn F. We got Sweet Blondie. Esmeralda Real. What's up, Sherry White? Linda Lou. Amanda Mandy Marr. Welcome. Russell Stringer and Kim Allen. Good to see you from Mock Schnell. Bringing in 20 new membos on the day. Thank you, Mock Schnell, for doing that. And welcome, new friends. We got this comment came in from James Anderson. Sponsored by Travis Matthew? Lots of them shirts. No, we're not actually sponsored by them. They should sponsor us, though, because you're right. We do have a lot of their shirts. I just happen to like them. I think the Travis Matthew shirts are pretty high quality. What I like about the Travis Matthew shirts is that they have, and we're not sponsored by them, but you can click the link on YouTube and buy a shirt and help support the show that way. But I just happen to like them because, first of all, their mediums are like size schmediums for me, which is exactly what we're trying to accomplish here. Thanks for asking about it. Brian Hinkle. I love Don Sr. Good to see you, Brian. Many of us do. Thank you, Brian. Good to see you. Hopefully your briskets are good. Hey, Nikki P. Hey, thanks for all you do, Rob. Appreciate you. Nikki, I appreciate you. Thank you for being here, supporting us for 23 months. That's a long time. We've been through some serious business, and we appreciate you. In the house. Old lady. Hey, old lady, this is great news. Great news. Says, my son is finally getting better. Thank you for your prayers. My son is finally getting better. My friends, thank you for praying for old lady and the son of old lady. We're very happy to hear that, old lady. Prayers work, man. We're going to continue to send them your way. Thank you, old lady. This one from King of Biltong. Sharing this. Says, biltong is one of the highest protein snacks in the world, boosting nearly 50% protein and packed with B12, creatine, iron, zinc, and more. Visit BiltongUSA.com and use code Robert for 10% off. From King of Biltong. Thank you, King of Biltong. Mock Schnell, what's up? 20 membos coming in. Courtesy of Mock Schnell. What's up? Wes Gibson is here. Christopher Benedict. We got Jeremy Haybear. Based actor. What's up, Cynthia R. Bass Goodwin? What's up, Joanne C. Oatman? 565. Jesse Van, Justin Schrank, Gregory Hutchins, Sean Price, Wade Baxter, James Lash, Misty is here. We got Spirit in the Sky, Brian A. Nocturnal, Teresa Stephenson, Designed Audio, and Eminem Drummer, Gifted Membos, courtesy Mock Schnell. In the house. Thank you, Mock Schnell, for doing that. What's going on, Ravicus? Says, this upsets me greatly. North Dakota Governor Kelly Armstrong signs Monsanto protection into law. Wow. Yeah, that's interesting. Ravicus. Looks like that's a Facebook post. Thank you for that, Ravicus. Hey, First Amendment says, hey, Robin watchers, I, for one, love Roman numerals. I, for one, get it? Thank you for that, First Amendment, but I love it. Hey, Doan. Helen Keller could finger a gump like Routh. That's pretty funny because, you know, Helen Keller was deaf and blind, but even she could say, that's the guy. Pretty funny. Sounds like they got a, you know, it's interesting. It sounds, I'm wondering if they have any other idea. Like, I think they have a cell phone. You know, they could probably triangulate it. Like, I'm interested in what other evidence they have for that. Hey, what's up? Fred Pedamonte. Rob, where's the New York Court of Appeals? What the heck? I know. We haven't seen it yet. Not coming. Hasn't come down yet. Thank you, Fred. Pritchie. Wow, that 15 months is gone by quick. Keep up the brilliant work. Thank you, Pritchie. Thanks for being here for 15 months, man. Almost coming up on 2 full babies. We appreciate you, Pritchie. Thanks for supporting us. Doan. The smart pay system is the misnomer of the era. Yeah, it's like the dumb pay system. It's like the fraud pay would be their actual name. Fraud pay. Or casino pay. Government bureaucrat grift pay. Yeah, thank you, Doan. Gloria B. Bringing in one membo. Thank you, Gloria B. Bringing in Snickle Fritz. Welcome aboard, Snickle Fritz. And God Bless America says cigarettes was not on the list. You're right. I didn't see cigarettes. We saw marijuana, though. Yeah. Maybe they're over the cigarettes. They just want to get high. Hey, hi, Sev Russ. What's up, Sev Russ in the house? Good to see you, Sev Russ. Bringing in Jonathan Haynes, Tigris. We got Cheryl Fetzer, Floppy in the house, and James McAllister. Gifted membos, courtesy of Sev Russ. Thank you, Sev Russ, for doing that. Jeffrey Adams, 20 minutes to liftoff, baby. 17 and counting. And so I think we'll wrap it up, and that will be perfect timing for you to go watch Elon blast off. Is this the one, the chopsticks? Is he going to catch it again? That's pretty cool. All right, so my friends, let's see what's happening on X. Then we're going to wrap it up. Membos, stick around. We're doing our members only after party today. As soon as we say what's up to our friends on X. Mini Tika, thank you, Mini Tika, for sharing the link on Rumble. Hey, saying support Eric's House with Rob this weekend if you're in town. Or sign up on, it's virtual. They're not doing the catch today. Oh, man, no chopstick catch today? That's a bummer. All right, so grab the link, Eric's House. Join us Saturday. Your boy is going to give a tour and talk about some serious issues over there. Hey, Fred Pedamonte, I really want to know who's paying for all his attorneys. Which one? Oh, Routh? Good question. I don't know. CIA? James Pepper, the Biden auto pen scandal came from the movie Dave. Thank you, James Pepper, for that. Jody says, hey, Rob, great show as always. Imagine 2 women fighting over protecting 2 men. God bless y'all. Good to see you, Jody. And Pro One Bro says, hello, friends. Hi, friends. Hi, Pro One Bro. Great to see our friends on X. And what a beautiful day. All right, prayers up. Prayers up for Colleen Page, says, need prayers. I have breast cancer. Colleen, we're going to send some prayers your way. Healing prayers. And they work, as old lady can attest to. So they're going to be coming your way. Man, cancer sucks. And we're hopeful that you feel and receive the prayers. My mama had breast cancer, and she pulled through that one. So shout out to our breast cancer survivors out there. You guys rock. Colleen Page, we're going to be sending prayers your way and encourage a speedy recovery. God Bless America also became a new membo. Thank you, God Bless America, for doing that, which is great. New membos, stick around because we're going to have our members only after party. YouTube members, go to the main channel homepage, hit refresh in about 3 minutes. We'll see you back over there. Locals, friends, don't move a muscle. The stream will pause for a moment and we'll be back in no time at all. But my friends, that is going to be it for us on the day. Happy Tuesday. I hope that your Taco Tuesday, Papusa Tuesday, whatever you're getting into is amazing. You're enjoying it and having a beautiful, beautiful evening. Of course, we're going to pause right there for the morning or for the evening. Tomorrow morning, we'll be back with the member stream. Members, stick around. We'll debrief on the after party for a little bit. But otherwise, my friends, I want to thank you for being here. Thank you to our amazing mods and meme smiths who mod the fort down for us and keep things oh so nice and beautiful and orderly around here. K-Bean, John, Donut, Carrie B, Just Rhonda, G-Gum, Elliot, Docmaster, Janek, Dog Digger, Neuro D, all of our amazing mods. We love you all. Thank you all for helping and keeping this train on the track. We're grateful for your assistance and your support. My friends, that is where we will leave it on the day. We are coming back tomorrow, and we're going to get into it again. But in order to do that appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through